This is August 16th, 2001. This is Elizabeth Townsend. This is an interview for Dean Massaro's Preparing for Lives in the Law Project, and this is Larry Hammond. All right, first question. Why did you go to law school, and was it what you expected when you got to law school?
I had no idea what law school or the law was about. I had never met a lawyer. There were no lawyers in my family. I have really not a very good reason for going to law school. I had a very substantial speech defect, and I've stuttered very badly, and it had plagued me all through high school and college. And I finally decided that I either had to succumb to it or overcome it, and one way to overcome it was to put myself in a situation in which I would just have to talk. And that's what I did. And that really had not much to do with being a lawyer, but had more to do with sort of helping overcome a little bit of difficulty.
So how did you do that? Did you just start speaking in class? Or
with great difficulty. No, I didn't. I didn't really have too much success with my speech defect in law school, but it made me work a lot harder than maybe I would otherwise have worked. I stuttered my way through most of those tense experiences in class when you get called on, and managed to get through law school all right. And
so do you have any advice for others who are afraid? Or we had someone else who said that they were terribly shy and that they sort of learned to get over being really terrified, shy. So that's kind of, it's different, but it's sort of, there's lots of students who have things like that.
Sure.
Do you have advice for them?
Yeah, my only discovery, and it wasn't one that I had thought about at all when I was trying to figure out how to overcome my anxieties, was the concept of having a client. It seems silly to think that a lawyer wouldn't think about having a client, but I didn't. But when I actually had clients, when I had people who were dependent upon me, what I found is they were much more nervous than I was. Their anxieties were much greater than mine, and it became evident to me almost subconsciously that if I allowed my anxieties to interfere with what I did, I was really hurting them. And I was really making their problems greater. And so somehow it just seemed almost natural and easy to say, look, if you're going to do something as a lawyer, you have to be the person who gets through the anxiety, who stands up and talks for somebody else. And somehow it became easier for me.
That's really interesting.
I don't know why, but it did.
And did that happen pretty quickly once you started with clients? Or, I guess we talked a long time about being shy, so we won't spend a lot of time on this, but and sort of overcoming that and all of that. If you just keep thinking about that it's not about you, it's about the client, that sort of...
That's part of it, and then for most people who are shy, there is usually some epiphanous event. There is something that happens. I'll tell you very quickly mine because it happened here in Tucson. Shortly after I joined the law firm that I've been with on and off for 27 years now, I was asked to represent the NAACP in the school desegregation case here in Tucson. And my co-counsel, who is a lawyer here in Tucson, Reuben Salter, and I took on that case on behalf of the black children in Tucson. And at the first hearing in federal court, was the first time that I'd actually been a lawyer in a federal courtroom, I stood up and spoke into a microphone. And I have no idea how this happened, but there was something about representing all of these children and hearing my voice in a courtroom that caused me to not stutter. I can't tell you why it happened, but it did, and I still, as you can tell, I still have a little bit of a halting speech pattern, but it's not anything like what it was before. So, but I've found that happens to everybody. Something will happen that causes you to understand that being a lawyer is not about you. It's about helping other people. And when it happens, it just makes your own anxieties seem inconsequential.
Let me ask a couple more questions about that. In terms of help, it's one of the things Dean Massaro is really interested in, is sort of that legal counseling or helping other people or trying to understand your client's needs, and that it isn't just understanding the law, that there's more to it, and that how do you get to understanding what your client's needs are. Maybe, I don't know if you want to talk about that a little bit, but sort of, I don't know, it's a hard thing. There's lots of ways to approach it, so
Well, let me, most of my experiences in getting to know clients and their needs have been in the context of criminal defense work or in the context of prison litigation. I learned by experience that most lawyers, myself included, assume that they know what the client needs. They assume that because they read the pleadings or they read the indictment or they talk to some other lawyer who's responsible for the case, and they simply assume that all they know is all they need to know. And we all embark on the process of representing our clients without really thinking that we may need to get to know the client and that the client's interests and concerns may be quite different than we think they are. I had the very good fortune in the first capital case I worked on to work with a lawyer who was actually younger than I was, who was in the Federal Public Defender's Office, who felt that in our team of lawyers in that case, one lawyer's job should be just to get to know the client. And that lawyer went to the jail at least once a week, every week without fail, from the time that we were appointed until we went to trial, which turned out to be almost 2 years. And the things that we learned about the client, about the client's family, and about the case from just having somebody get to know the client left an indelible impression on me. And now it's an article of faith with me that part of representing a client is knowing the client. And we would set up agendas to talk about things that had nothing to do with the case. It was a murder case, and a horrible murder case in which 2 children had been burned to death, and the man had been charged with pouring a gallon of Coleman fuel on them while they slept. So it was a very difficult case, but we talked about things like his military career and his childhood and his marriage and his job as a taxi cab driver and the things he read. Each week, the lawyer who went to see him, and sometimes other people on the team would go, but basically the lawyer who had that responsibility just would ask him, what should we talk about this week? And they would talk about all kinds of different things, and it turned out that a lot of it was very, very helpful to us in understanding him. It turns out he had confessed, and his confession was false, but nobody would believe that somebody would confess to so horrid a crime had they not committed it. Well, once you understood him and the things that animated his thinking, a lot of things began to make sense. Turns out he'd suffered from migraine headaches most of his life and had a migraine headache at the time that he confessed. Well, understanding what it means to have migraines and what they meant to him was a very important part of the case. So we may never even have developed if we hadn't had those kinds of encounters. And I could go through every client that we've represented, and I could tell you some story about things that we learned that we didn't expect to learn. And part of it was just suspending judgment about this idea that all you know is all you need to know. There is no diminishing returns in talking to clients in complicated matters and getting to know them. You always learn things.
Are you going, okay, so I say, okay, that's really good. I want to do that. I want to be that kind of person. I want to be that kind of lawyer. How do are you going sort of to make them feel comfortable with you? Are you going to, how is the demeanor do they think that you're somehow their friend? Do you always appear is there a time when you have to make sure you don't cross? You're trying to get information. Is it sort of, it seems like it's a very
important question, and it's hard to answer, and I don't know the answer, what makes it even harder. But let me talk to you about trust and confidence for a minute. In the criminal defense world, there are at least 2 schools of thought about relationships between lawyers and clients. You'll hear and see some lawyers who will say, I don't want to know what really happened. I don't want to know everything the client has to say. I just want to know what the defense is. And that's a respectable position, and there are lots of good lawyers who feel that way. There's another school of thought that says that there ought to be a relationship of trust and confidence, and particularly in cases in which someone's liberty is at stake or their life is at stake. It's very important that somebody know that client and develop a relationship of trust and confidence. Well, how do you do that? The truth is that most clients have never really had a lawyer-client relationship. They don't know what it means to be a client. Most of what they think about what it means is born of secondhand experience with friends or family members or what they saw on television. And so what they think about you as a lawyer may have very little to do with what you think of yourself as a lawyer. So one thing that has to happen is that in addition to getting to know the client, I believe it's very important for the client to get to know you. So sometimes just having idle conversation in which the lawyer talks about her family, her interests, are and can be terribly important because you're developing a relationship of trust. It's hard to have trust in somebody you don't know. It's hard to have confidence in the judgment of someone who you have no idea about. So knowing a little bit about what they've done as a lawyer, where they went to law school, what kinds of things the lawyer likes, are all part of that process. And of course it varies from client to client, but I think the basic idea is that you have to develop a relationship almost as you would with somebody who's not a client.
Okay, so I work at your law firm, and you say, okay, we got a new person, you got to go this week. What's the, when I first see them, I mean, how do you say, I'm going to see you every week? I mean, how does it work? I mean, and how much do you tell them that, like, do you know what I mean? How do you set up that relationship, and is it just...
Well, what we have found is that first of all, you can't do it in one meeting. There's nothing you can say in the first meeting that is going to capture the relationship. It just won't happen. So what we do is we say relax. We say this to our own lawyers. Take it easy. Don't feel like you have to have an agenda that accomplishes a particular goal the first time you meet a client. Try to get to know the client a little bit. Try to understand what kinds of things help that client trust you. And it may not be the same thing in each case. It may be entirely different. But actually, our younger lawyers do a better job than the lawyers with more experience. In part because they're genuinely, that one of these things that people say is the most important thing in lawyering is sincerity, and once you learn how to fake that, you've got it made. Well, the truth is often that the young lawyers are really sincere. They really are interested in knowing a client. It's not a game. It's not something they're making up. It's something they really want to do. And if you're fortunate enough to have a lawyer in your office who really wants to know the client, these things become pretty natural. You want to go down to the jail and sit for an hour and talk to them about their family and your family, and what it's like in the jail. There are always lots of questions that become pretty evident when you sit down and talk to people.
Do you have to, can you get too close to a client? Mm-hmm. Is that, and do you have to guard against that? You do ask really good questions. It is true, and you do have to be. It's important that the client understand, and again, it can't be done in one conversation, but your value to the client is in very large measure dependent upon your independent judgment. And having independent judgment does require that you not become so personally involved with the client that you can't think independently. It's the same reason why most lawyers will tell you that they can't represent their husbands or they can't represent their children, because they know they wouldn't have that objectivity. If I have a client that I have become so enamored of that I can't step back and exercise independent judgment, I would say I no longer should represent that person. I really can't. And is that something that you would tell the client as well? I mean, how much do you let the client into what you're doing? And I mean, you're doing all the personal stuff, so it's sort of that connection. But what about the legal relationship? Is that, how much are you sharing with them on that part of it?
Well, my personal view is that the client is entitled to know everything you do. There are some decisions that I believe are quintessentially the client's decision to make, and some decisions that are really for the lawyer to make. But the client is entitled to know about all of it. So we try to make sure that in our conversations with the clients, they understand every step in the process. They understand how much discovery is allowed. They understand where the money's going to come from, who's paying for these things. They understand the time schedule, we hope. They understand time extensions. They understand the basic things that every client, I think, is entitled to have some insight into. And then at some points along the way, and it very rarely is the first meeting, there are these critical decisions that have to be made. Whether the client is going to plead, and if so, on what ground. Whether the client is going to testify. I believe is quintessentially the client's decision, understanding that there are some things a lawyer cannot do. A lawyer cannot put the client on the stand and have the client lie if the lawyer knows the client's lying. But the opportunity needs to be there for the client to understand that. So at some points along the way, and I don't think it's always the same point, it sometimes happens at different times, we almost always have a trust and confidence conversation in which we explain to them that you need to be honest with us. We need to know everything that happened here, but please understand that once we know the truth, there may be some things that we can't do for you. Very hard conversation to have.
So what happens when someone doesn't tell you the truth and you find out later? I mean, it seems like it get really hard. I mean, because you've now got a personal, I mean, you invested in the person, and it's bad, but it seems like it could be even worse.
Well, it does happen in the career of every lawyer that you find out that someone who you've tried to develop a relationship with has lied to you. But it's part of it is a byproduct not of the client doing something bad or something totally blameworthy, but because of this whole world of what lawyers are and what clients think lawyers are. I think a client can be forgiven for distrusting lawyers. We have a society that is built on the notion that lawyers can't be trusted. So why should a client sitting in the Pima County Jail assume that you're going to be the one lawyer who they can really trust? Even though you say it 10 times and even though you're just as nice as you can be, they have reason to distrust you. And they talk to other inmates who will tell them all the reasons why you can never trust your lawyer. Mm-hmm. So I try to say I don't draw too many conclusions about why people don't tell me the truth, and it does hurt, and it may hurt them. But I think you just have to understand that's going to happen.
That makes a lot of sense. It really does. What about, okay, so this is a very involved process. You always hear everyone doesn't have time for anything, and this is a very sort of slow, not old-fashioned, but sort of taking your time kind of thing. Do you do it only with really capital cases or very serious cases, or how do you deal with clients when it's not so serious? I mean, do you know what I mean? How involved? I mean, you can spend your whole day doing that.
Let me approach it from a little bit of a different standpoint. A lot of the work that we do that we don't get paid for might fit under the banner of indigent defense. I've been fortunate to serve as the chair of the State Bar Indigent Defense Task Force for the last 8 or 9 years. We try to maintain very close relationships with the public defender's offices. We try to talk to them about what their days are like. if they saw the last 20 minutes of this, most of them would go, where does this guy think he's coming from? The average time spent per felony in the Maricopa County Public Defender's Office in the last year was 8 hours from beginning to end of the case. Well, if you put what I said in the last few minutes in the context of an 8-hour representation, you would see that it can't be done. Having said that, what I try to tell public defenders is you have to raise the bar yourself. If you go into a public defender organization, you will be propelled in the direction of spending as little time as possible. You'll be propelled in the direction of not communicating with your client because nobody else does. And because you don't have time, and you've got 1,000 good excuses for why you can't spend time. In the majority of felony cases, and I'm not talking now about capital cases, but I'm talking about cases in which someone's liberty is at stake. In the majority of cases, the first communication with your client is the conversation in which you talk to them about pleading, which I think is unforgivable, even though it happens every day in Maricopa County and in Pima County. I ask lawyers, how would you feel if the first time your lawyer came to see you, it was to suggest to you that you might want to plead to something that will put you in the Department of Corrections? Somebody you've never known, somebody who you have no idea about whether they care about your case or not. I think you have to, but the organizations won't raise that bar for you. They won't say to you, you must go meet your clients. They'll say, here are your files, read the police reports, and let's see what we can do about these cases. Well, in that context, it's pretty difficult. So you have to push back a little bit, and you have to say, I'll do these cases, but I don't think I can do them as quickly as you want to have them done. I think I need to get over to the jail. I need to meet the client. I need to meet the client's family. I may need to do a lot of things that typically people don't do.
Do you think that, it's better for the client, but do you think it's not better for the, I think people would be scared that they'd be penalized because they're not getting as much done.
Which people?
The young lawyers who think, yeah, I want to do that, but, or they're going to end up spending, their entire life trying to do it and never even eating dinner,
Well, part of it is experience. There are some cases that you can look at, and you can look at the police reports and a few other pieces of paper, and you pretty much know what's going to happen to this person. The vast majority, I think it's like 60% now, the people in the state prison are 27,000 inmates in the state prison. About 60% of them are drug-related charges. Most of those cases are slam dunk cases from the prosecution standpoint. Whether they get to know you or not, whether you get to know them may not make very much difference. And so when you've been doing it a little while, I think you can get some refined judgment about how you spend your time. But it's a terrible mistake to think that every case is alike. And the process is designed to make defense lawyers and prosecutors think that every case is pretty much alike. So you have to kind of take it a step at a time, I guess, and try to understand that you don't come to this with anything like perfect judgment in the first place. So if it takes you a little bit longer in the first couple of years, that's just the way it ought to be.
What about, we'll move on to the topics we had planned to talk about, but what about the whole thing of clients' families or other problems my family's going to be evicted and we don't have the money to pay the rent, or all the sort of things that as you get closer to clients they confide in the problems, and sort of maybe your thoughts about that, or sort of the role of a lawyer and all of that.
Well, let me give you an example of that. For the last 6 years, my partners and I in our law firm have represented every inmate in protective segregation in the state prison system. There are now 780 individuals who are in what's called protective segregation. They're the lowest of the low. They're the people who are regarded as rats or child molesters, known as chomos in the prison. They're the cops who have been convicted. There are HIV positives, gay men, who wind up being the very bottom rung of the prison system and are the victim end of the population. We were appointed to represent them at a time when the director of the prison system was going to put them all back into the general prison population. He called it mainstreaming. Thought it would be a good idea to get them back. We were sort of mollycoddling these people by keeping them in segregation. So our mission was to do one thing: keep them safe, keep them in protective segregation. And we knew we had a terrible job even doing that. But immediately we began to have your issue. We began to find out that these were human beings who, in addition to needing protection, had other problems. They had sick mothers. They had a book that they really wanted to read, maybe even the Bible, that they couldn't get. And they had nobody else to talk to and no place else to turn. They couldn't get visitation. They couldn't make their telephone calls. There was glass in their food. And we had to decide, what are we going to do about this? We've got a team of essentially 4 lawyers who are doing this case. If we tried to do all of these other things, it would be totally impossible. But if we didn't respond to some of these things on a human level, we would be disserving all of these people, and we would be creating for ourselves a reputation as not the kinds of lawyers who really wanted to help these people. And what we decided to do was to take it on a very ad hoc basis and to trust the judgment of the lawyers who were working on the case to say, look, we've got an enormous amount to do. We've got very limited time and resources. There are some things that we just are going to have to say, I'm sorry, I cannot help you. But we also tried to get to know how you answer those questions. So we tried to get to know the chaplains. It doesn't take a long time to get to know a chaplain. You could set up a lunch and find out something about them. So you've got somebody now you can call up at prison. We tried to get to know the counselors a little bit. So there's another kind of way you can help solve people's problems. And we tried to do little things like that so that we could at least point the inmate in the right direction, even though we couldn't really help him.
That's really interesting.
And I think it helped. So it I think seemed to a lot of us that we didn't have to just say we will help them or we won't help them.
It seems like that could get translated into a variety of, I mean, not just what you do with criminal defense, but all kinds of things where people are coming to you with problems, but if you get to know the community, you can help them, direct them in a way that you might not think about. It's a really interesting idea.
Yeah.
You don't have to take on the responsibility, but just get to know the people who can help you.
Yeah. And I'll tell you, I've had this experience many times. I would like you to meet some of my partners because I think it would help you understand how this happens. But I've been really fortunate to have great lawyers to work with who are great in lots of different ways. There have been a number of times in cases in which a client, an inmate, either somebody who's already in prison or somebody who's about to be there, would say, Larry, I want you to help me with X, Y, or Z. And too often my reaction is that closed, oh my, I can't do another thing. I just can't do it. And I've come back and said, I'm not going to do it. And then one of my colleagues will say, well, Larry, I'll take care of that. I think it's a phone call. We could point him in the right direction. We could find something for him to do. We've had a number of those cases. I'll tell you a little story about one of them because it involves a guy who is here in Tucson. In the prison case, there was a fellow who is now dead whose name was Peter Nerschel. Peter was the worst of the worst. He was the founder of the Aryan Brotherhood in the state prison system here. He was as hateful a human being as could be imagined. He covered his body with tattoos from head to foot. He had the phrase Aryan Brotherhood stenciled on his back. He was the enforcer in the prison system. And somewhere late in his career, he found religion. And he switched. And all of a sudden, he wouldn't kill people anymore. He'd killed 3 people in prison after he'd already been sentenced to life. Well, he became one of the key witnesses for us, helping us prove that the open yards were violent places to be. Well, after he started helping us, we found out that he had AIDS and that he was dying of AIDS. And he had what some people might call little issues, like his hands and his feet were always cold. His circulation was not good. He wanted gloves. He wanted a beanie that he could wear. But I'll tell you honestly, my first reaction when he started talking to me about that stuff was that closed, we have too many people and too many witnesses and there's too much to do. But Debbie Hill, one of my partners, said, well, wait a minute, Larry. We can, I think we can get him a pair of gloves. And you think about it and think, well, only a fool would think that you don't have time to help somebody get a pair of gloves. Well, she did that. And in the process of doing that, she got to know the counselor. And the counselor said, well, there's some other things he needs. In the summer, he needs a fan. We called somebody in Phoenix who has a fan company, and the first thing you know, he's got a fan, and the other inmates who need fans, who are in protective segregation, also have fans. It may have taken an hour of her time. It made a tremendous difference and helped establish the relationships with those clients. This man eventually died, really a tragic death, and we spent the last year trying to get him help, trying to get him released to his family, which didn't work. But he had a memorial service after he died down here, and we came down and spoke at the service. And of course, he'd been in prison for 20 years, and so the people who came to the memorial service were the families of other inmates. And seeing those people, and seeing what they think of lawyers because of the time that my partners had spent with him was really a tremendous experience for me. And it left a kind of an indelible, sort of a little bit too emotional feeling about it's worthwhile taking a little bit of extra time. And I think if I'd been doing it alone, it wouldn't have happened. So, but every lawyer who I've talked to who has had these kinds of experiences comes out of the same place. Somewhere along the line, you learn that there's a lot more to being a lawyer than just doing the job you've been given to do. And finding that line for yourself and finding how far you can go without sacrificing your judgment and your independence and giving up your family.
What about, you said something about that she called a fan company.
Yeah.
Is that using the community as well? Again, that goes back to you didn't buy the fan, you didn't have
Sure.
to put the bill for it.
Sure.
And it seems like it's a very creative way to go about solving problems.
People will it's amazing what people will do if you let them know. And if you're cautious about the times when you go to other people to ask them for help, cautious in the sense of making sure that you're doing something that's worth spending time on. I very rarely find anymore that people won't help us when we need help, particularly on little things like that.
How do you ask them? You just say...
I go to my partners and ask them to do the asking. We're pretty direct. Do you know about the Justice Project? Has somebody told you about that? We started, Arizona Attorneys for Criminal Justice started 3.5 years ago something called the Justice Project, which is an all-volunteer organization. We try to assist inmates who believe that they're victims of manifest injustice in the criminal process, basically people who are innocent or who have been sentenced in a way that is totally off the wall. We have never had any money. We have never had anybody donate any significant amount of money to us. We've never had a foundation grant. Everything that we've done for 3.5 years has been based on people donating their time and resources. And we now have we've reviewed over 700 cases. We have 50-something cases that are being actively managed. We have students here at this law school who have helped us, and half a dozen faculty members here. We have 30 or so students up at ASU and faculty members there. And we've gotten paralegals and experts, fingerprint people, pathologists, just a whole variety of people to donate their time to particular cases. And what you find is if you go to somebody and say, I think we have a problem here. This could be somebody who has been convicted of something they didn't do. Do you think you could help us do the fingerprints, or do you think you could help us do anything? It really amazes me. Very rarely do people say no. They often say yes and then don't do it. But we very rarely have people say no.
That might lead into one of our, we haven't gotten to any of our topics yet, so let's try to get to one.
Okay.
Public service and lawyering, because that seems like it's kind of pro bono and giving your time, and that's like a huge, so maybe we could talk a little bit about that if you want, or we can go
Sure.
on.
Yeah, well, I like talking about that.
Okay.
First of all, I think it depends a lot on what premises you start from. I would hope that most lawyers would start from the premise that being a law person, being a lawyer, is part of being in a public service profession. Indeed, I don't think there is a higher public service profession than being a lawyer. And I would hope that lawyers would think of their careers as essentially careers in public service.
For someone, what does that mean? That's a hard thing.
Well, what I think it means is that first of all, participating in the justice process, whether it's as a litigator or whether it's somebody providing advice in a non-litigation context, is essentially providing a service that is a very important service. If we didn't have lawyers, we wouldn't be able to have a system of justice in this country, either civilly or criminally. We get paid for some of that work. And if we're lucky, we get paid for enough of it to keep an office open and to feed our families. But it's not a healthy thought to say that I will only do the things that I get paid for. It's not healthy for you as a lawyer to say that, because you will foreclose yourself from doing a lot of things that may turn out to be the most meaningful things you could do. The continuum of problems that people have don't stop where the dollars do. There are lots of important things to do that we don't get paid for, and there are lots of important things to do that we do get paid for. And it seems to me that a really helpful way to approach being a lawyer is to think about how you manage your career so that some of the things you do, you get paid for. And those things that you get paid for may allow you to become good at what you do, to be competent enough to do them efficiently, and then to have some time to do things you don't get paid for. And I think there are lots of lawyers in this state who approach it that way, whether they know it or not. Some lawyers do that and never really realize that that's what they're doing. But if you look at the criminal defense bar, for instance, one of the reasons I'm very proud to be a criminal defense lawyer in this state is that there are so many lawyers who are doing that, who recognize that we can't get paid for everything, and that whether you get paid or not, it's still a public service. It's as much of a public service to represent a client that you get paid $325 an hour for as it is to represent someone who you don't get paid a penny for.
And okay, so I'm a young lawyer and I want to do that, but how do I figure out what to do? Do people just show up and you help them, or do you go to an organization, or?
Yeah. Well, let me step back from that question too. The best advice I received as a young lawyer came from a judge in Washington, D.C., who I clerked for the first year out of law school. I had, like a lot of people, I had gone to college and to law school straight through. I'd been in post-high school education for 7 straight years. I thought, well, now my education is over and I'm going to start being a lawyer. And I was fortunate enough to have a judge say, no, that's not really a very healthy way to think about it. You really don't know a lot. And there's a lot to learn, and there are tremendous opportunities for doing good as a lawyer. And his advice was, why don't you take the next 7 years and think of those years as part of your continuing legal education, which to him translated into essentially doing as many different things as you can. Don't make any decisions about how you're going to spend your life as a lawyer. Think about diversity. Think about different kinds of experiences. Think about teaching a little bit. Think about going back to a law school somewhere and having some kind of a relationship with the law school in some way. There are lots of needs for adjunct teachers at every university, whether at a law school or someplace else. So teaching is a good idea. Law clerking is a very good idea. There are lots of things to do in that area. Public service organizations. Arizona is full of them. I've never seen so much vibrancy as we have in Arizona right now. We have the Florence Immigrants and Refugee Rights Project, which I think is one of the, I'm really thrilled with what those young lawyers are doing. But they're all over the state, and they're the prosecuting offices. I think being a prosecutor is a very good experience. I think working in a law firm is a good experience. Being a public defender, working for the ACLU or for another foundation, all of those things are good, and they will give you experiences and help you broaden your approach. And if you do those things, you may be able to put off a little while having to make some of these difficult decisions that you were asking about.
Does it sometimes people? I mean, they're starting the whole on-campus interview thing now, so it's all flurry. There's a real sense of people trying to get like just the best, biggest, fastest, like the best, the best job you can get, meaning the most money, the most.
Mm-hmm.
And this doesn't go quite to that. What about the people who are afraid that somehow they want that corporate job later, they may not be able to get it because they did something quirky after school? Is that a fear that they should worry about, or?
Well, let's break it into 2 pieces. I'm very sensitive to the economics of legal education, in part because I wasn't burdened by it. Because as I told you before we went on camera, I went to a place that was as close to being free as a university could be. But I have 3. I was going to say children. I think they think of themselves as adults, and one of them is about to enter law school, so I have a kind of a rich, immediate sense of what this is about. I understand that there's a need to pay back those loans. I understand that there's a desire to get out there and make some of that money that is available at the law firms that are paying $120,000 a year for first-year students. And I don't deny that that's something that law students ought to be thinking about. But I think that they cheat themselves if that's all that they think about. Let's take a real concrete example. A first-year law student has to decide how she's going to spend her summer after her first year. Going to have to make that same decision after the second year. Why would someone, particularly in Arizona where there's so many interesting things to do, why would somebody choose to spend both summers at my law firm, for instance, which is a wonderful law firm, but at my law firm or any other essentially corporate law firm? Why would they not spend part of a summer as an extern for a judge, or part of the summer as an intern in a public defender's office or a prosecutor's office, or with the Florence Immigrants and Refugee Rights Project, or with the ACLU? Why would they not? it's not going to hurt their chances of getting a job ultimately with a big law firm. In fact, it will enhance their experience. But I would submit to you, at least the law students that I talk to often don't think about doing that. They get into the rat race, and I think they need not do that. I think you can do all of these things.
That makes sense. So let's move to our first topic, which is judges. You clerked quite a bit and quite impressively.
I flunked judging.
You flunked judging?
I flunked law clerking.
You flunked law
3
clerking.
times.
Tell us about. So you finished. Let's go back. So you finished law school, and you go clerk immediately.
I spent a summer at a law firm in Los Angeles. We had decided that that's where we were going to live, and then I was going to do 1 year as a federal law clerk and then go back to Los Angeles. That was the plan.
And what happened?
We went to Washington, D.C. I'd never been east before. We went to Washington, clerked for a judge on the D.C. Circuit Court of Appeals, the judge who gave me the great advice, Carl McGowan was his name, now deceased. And in the middle of that year, I got a call from Hugo Black asking me if I would come talk to him about being a law clerk. And he was the only justice on the court that I wanted to clerk for. And he offered me a job, and so I went to work for him. And I called the law firm in LA and said, could I come next year because I'm going to work for Hugo Black. And then Black died shortly into I guess maybe 3.5, 4 months into the clerkship. And the Chief Justice then said, well, we have a tradition of letting law clerks hang around. And we offer them up to whoever the successor is. So I hung around and did all of Mrs. Black's condolence notes, read the New York Times and the Washington Post, played pool and basketball, sort of debauched for several months, and then Lewis Powell came along and asked me to work for the rest of that term as his law clerk. And I did, and then toward the end of that time he asked me to stay for another year. So I called the firm in Los Angeles and said, could I come next year? So I did that for a year, and then Archibald Cox was appointed the Watergate Special Prosecutor. And he called and asked me if I would come talk to him. So I told my wife, I promise I won't take this job, but I'd really like to go meet this guy. And so I went and met him, and he never really asked me if I wanted to work for him. He just assumed that I was going to work for him. And so I really couldn't tell him no. And so I told my wife no, and then I called the law firm in Los Angeles and asked if I could come a year later. And that made it then 4 years, and by that time I didn't want to go to Los Angeles anymore. But that's sort of how that happened.
That's amazing. You've seen so much stuff. I mean, that's amazing.
Had a lot of fun.
That's really cool. So what are your thoughts about, I'm going to do a little bit better on the question, but sort of your first thoughts, or your first experiences working with a judge. What was that like? And
First of all, I think working for a judge, if you can do so, is a good thing. It will give you insights that you just can't get anywhere else. You see lawyers from a very interesting perspective. Almost everyone I've talked to who has clerked has come in one way or another to the conclusion that lawyers don't do as well as one might hope they would. They don't write as well. They don't think as carefully. They don't represent clients as thoroughly as you would like them to. That's an insight you can tell someone about, but until you've actually sat with a huge stack of papers and read through the briefs or watched oral arguments or seen a trial from the perspective of a judge's law clerk, I don't think you can really get it. So getting it that way is a very good thing to do. And being around a judge who really cares about doing justice it's a nice way to set the foundation stones of your career. And there are some excellent judges in this country and in Arizona. So from that perspective, I think clerking is really a good thing. My views on judges generally, though, has changed over time. When I first came to Arizona in 1974, I frankly was appalled by the quality of the judges. Having had the sort of rarefied experience of seeing judges on the D.C. Circuit, to then come into the Maricopa County Superior Courts or into the Pima County Superior Court, I was very disappointed in the judges. A lot of whining. Judges are great whiners about how overworked they are, about how they have too many files, about how they can't possibly read through a whole motion. How dare you submit something that exceeds the page limitations? How dare you ask for an hour oral argument? I found it pretty discouraging, but I think the judges have gotten a lot better. Not all of them, but I think we have better judges today. I think the appointment process is better. Taking judges out of the election process has yielded a better quality of judges. There are relatively few judges in Arizona who I would say you shouldn't spend a year clerking for. I think they're all interesting enough and diverse enough that you could profit handsomely from working for almost any of them. And I wouldn't have said that in 1974. I think we're doing well.
Because of the merit selection process?
Merit selection has made a huge difference. Bruce Babbitt made a great difference. Babbitt really committed himself, it's now 20 years ago, but he really committed himself to the idea that we ought to have good judges. And so he elevated the concept, he elevated the idea of being a judge to something that somebody would want to do just because it's a great public service, as opposed to doing it as kind of a thank you for being someone's campaign manager, or as a way to ease into retirement. We started having a cadre of judges who really cared about judging, and I think it started with Babbitt.
Do you think that people, I'm going to ask you a gazillion different questions that aren't going to relate at all, do you think that people, you said something about close to retirement, can you want as your goal to be a judge? I mean, if you're a law student, you say, I want to be a judge. Is that a possible goal, and is there certain ways to get there, or is that just something that happens?
Yeah, in Arizona, if you want to be a judge, the first thing you need to do is embrace the death penalty. Decide that you believe in capital punishment. And so my advice to most people is don't do that. When you decide early on in your career that you really want to be a judge, frankly, I think you start sacrificing your independent judgment. Being a judge is something that ought to happen because you have piled up a lot of life experiences, you've learned a lot of things, and you have worked hard in this public service profession. I don't trust people who decide very early in their careers that they want to be judges, because what they start doing is figuring out not how I be the best lawyer or the best public servant, but how I meet the right people, how I manipulate other people to get them to see that I'm judicial timber. So I'm pretty skeptical about people who decide that they really want to be judges and then go out and pursue that.
Interesting. Okay, what made you such a fabulous law clerk?
I really wasn't a fabulous law clerk. Nothing made me a fabulous law clerk. I enjoyed being a law clerk. I loved it. I loved every minute of it. I just thought it was just a rich kind of experience.
What did you give me more examples about what you loved about it?
Okay, well, I'll tell you about the first day I worked for Lewis Powell. Having worked with Hugo Black, a man who knew his mind on every topic, there wasn't any topic that could come before the court that Hugo Black hadn't already addressed in his career. And so being a law clerk, while it was pretty interesting to be around some people who were that much a part of American history, in terms of the kind of intellectual contribution, I didn't really have the sense that I was contributing very much. I mean, Black would say things like, would you go to the library and get that thing about the muses? I like that line about the muses. There's something in the library about muses. And you'd run off the library and that was sort of interesting, but I didn't really feel like I was adding much to the intellectual weight of what was happening. Lewis Powell came on the court, and he had the first meeting with us. He said to us, look, I've been in corporate practice all my life. been the president of the American Bar Association, and I've said a lot of things about the criminal justice system and about constitutional law, but I really don't know very much about that. And I want you to assume that I know nothing. I want to take every issue that comes before me, particularly constitutional law issues and criminal law questions, and I want you to assume that I don't know anything about them. And I want to start at ground up. I want to look back at the roots and the origins of things, and I want to read all of the relevant cases, and I want to read all of the Madison's notes from the convention, and it was like dying and going to heaven for the rest of that term and the next term, being around somebody who really wanted to figure out what the Equal Protection Clause was about, or what the First Amendment was about, and who really had set aside his biases to say, help me understand how we got an establishment clause, or what the word reasonable in the Fourth Amendment really means. I mean, how could you have more fun than that? And it made clerking a tremendous experience, because every time a case would come before you, you'd look at the briefs, and the briefs wouldn't really address the roots. Lawyers, for some reason, often don't do that. So we would scurry around and try to figure out, how did we get the Bill of Rights? How did the Fourth Amendment get into the Constitution? How did the body of cases develop? You just can't have much more fun than that.
That's really cool.
So.
And what about when you worked for the D.C. judge? What was that like?
He was at a point in his career where he was still sorting out what he wanted to do with law clerks. He'd been a judge for 7 years at that time. He had not had his clerks do very much writing, but he was open to allowing us to try to write stuff. And so he said to us very early on, if you want to try to write an opinion, go ahead. I can't tell you what I'm going to do with it, because I'm not accustomed. I do my own writing, but if you want to, go ahead. And so we did. And we got into the habit of doing first drafts for somebody who hadn't really had that experience. And it was really a very lively process of seeing him change his attitudes about how he wanted to use law clerks, and at the same time giving us a chance to really do a lot of writing.
Do you have any advice to give to students who may be going off to law clerk, or from all the... You work for quite a...
Yeah, I think that the advice sort of works for itself, but I've encouraged people to recognize how extraordinary those experiences are, and to make the most of them. And making the most of them sometimes requires a little bit of an intellectual jump. Not all of the judges in America have the same political views that the law clerks do. We don't all have the good fortune to have people who we instinctively agree with. And so one of the things you have to do is learn how to suspend your own judgment, how to set aside your own biases, how to listen to other people, how to think through somebody else's eyes. It's a hard thing to do.
It seems like lawyers have to, that it could apply to clients as well, that's kind of what you have to develop. That whether it's on either side of judge or client, that you're constantly, that's one of the things Dean Massaro keeps, that you can't just stay with your own biases, that it's learning to understand others. I don't know if you'd agree with that or not.
I do agree with that. Have you seen the movie A League of Their Own?
Yeah.
Do you know that movie?
Mm-hmm.
It's the, when people ask me what's the greatest lawyer movie, I say A League of Their Own is the greatest lawyer movie. There's a place in that movie where Gina Davis is going to quit the team, and Tom Hanks is about to get on the team bus, and he sees that she's not getting on, and he stops and he walks over to her and he says, "We're about to leave." And she says, "I'm not going." And he says, "Why?" And she says, "It's just too hard." And he looks at her and he says, "It's supposed to be hard. It's the hard that makes it great." I think that's what lawyering is all about. I think that the hard things about being a lawyer are what makes it worth doing. And so when you talk about these difficult things about developing relationships with clients, or suspending your own judgment, or finding the time to do things right, what I say is that's why you're doing it. I mean, that's what it's all about. That's why it is so much fun.
That makes sense. Okay, what about being in front of judges? So you clerked for them, and then you spend a lot of time in front of them. Do you have thoughts about them on that side of it?
I do. And I may want to censor this after. While I said, and I honestly believe that the quality of our judges is greater today, is better today than it was 25 years ago. Certainly that's true at the state level, state court level in Arizona. I also think that judges, as a general proposition, could do much more than they are. I would hope that judges understand that the responsibility that they have is a phenomenal responsibility. And too often I see judges who, if they do understand it, don't reflect it. For instance, in my mind, there is no excuse, absolutely no excuse for a judge mistreating a litigant or a witness. People come into court scared to death. We talked about stuttering and anxiety. I mean, imagine what it's like for clients coming into court. And I don't care whether it's their liberty at stake or their house or their, whatever it is. When you go into a courtroom, it's a scary thing. And yet, incredibly often, I will see judges snap at witnesses. I will see them lose their temper at somebody in the courtroom. And it seems to me they often don't realize that everyone in the courtroom hangs on the judge's every word. Every word she says is important to somebody. And I think it's pretty unforgivable for judges not to recognize that. And thank goodness most of them do recognize it. I also think that judges do much too much whining about how hard they work. I'm one of my advice pieces for young lawyers. Maybe the most important thing I have to say is don't be around a courthouse at 4 o'clock in the afternoon. The chances of being run over are so great by the judges leaving. The droves of judges who have some place that they have to leave for 4 o'clock. Try to find a court in session in Maricopa County at 4:30 in the afternoon. And I think you'll find that the halls are dark, the courtrooms are closed. Where are all of these people who are working so hard? Too often you go into court in the morning on a motion that you've worked very hard to prepare for, and you find that the judge hasn't had time to read it. Some judges will be honest enough to tell you that they haven't read it. Some judges will simply lie to you and say, "I've read your papers, counsel. Move on. Give me your argument." Well, I really think that's inexcusable. I think being a judge is hard, and I think judges ought to recognize it's hard, and they ought to plan to spend the time that it takes to do judging right.
When you get in a situation where you think the judge hasn't read your work, do you approach what you're saying to him differently?
Yes, I do. First of all, I generally don't believe judges who say, "I read your papers," in the sense that, they may have, but I don't assume that means that they've understood what they've read. So I generally will say something insincere like, "I know that you're familiar with the papers, but let me just suggest a couple of the key points," and then I'll say exactly what I was going to say. Anyway, once I've gotten to know judges better, if I have a case that I'm around the same judge for a long time on, if I know that the judge is ill-prepared, it does affect the way I approach it. Rule number one, repetition. People that say in law school that you should learn not to repeat yourself. I'm exactly the opposite. I say you should repeat yourself. You should say what matters to you and your client over and over in as many different ways as you can, because the chances of the judge getting it the first time are not really very good. So I try to help people think about trying to say the same thing over and over again. It's true that it also affects your respect for the judge, and I try not to allow it to. I try not to allow it at least to show, and I encourage younger lawyers not to allow it to show. But the truth is that it's very frustrating to work with a client, to have the client understand what the legal issue is that you're raising in court, to have the client sitting by your side, and then to have that sick feeling that and if you have it, you know your client has it, that the judge just doesn't get it. And sometimes I find it real hard not to say, Your Honor, why don't we suspend this oral argument, and why don't you go read the papers or go read the case that you said you've already read. I've only done that a couple times, and it's kept me down in this humble lower reaches of the legal profession, but it's not a good idea to do, but it is frustrating. It's very frustrating.
What about the notion of reputation? We've gotten that a lot, about your reputation is important, or, from all sides of it. Do you see in that Tucson might be more, because it's smaller, the reputation, like being prepared and all those sorts of things, and being good and kind and all that matters? Do you see a reputation, it seems like if you had a reputation as a judge or as a lawyer of not being prepared, that would get around. Do you think it matters? Do you think reputation matters in any of, I don't know, just anything you want to talk about with reputation?
Yes, it matters at every level. It matters. Let's talk about lawyers first. It matters a lot in the way that you feel about yourself. If you have standards that you embrace as a lawyer, you know that there are things that you are going to do and say. There are ways that you will handle a case, and having a reputation for doing those things will help you continue to do them. For instance, being prepared. If you start out believing that whether it is necessary or not, you will always be prepared when you go to court. It will help set that as a kind of a stone in the way you look at yourself. It becomes part of your foundation. It is too easy to be unprepared. It's too easy to wing it. It's too easy to guess about what a case might hold. And if you do guess, you'll get away with it. I guarantee it. You will get away with being unprepared. Just like sometimes when you go to class. By the way, I've been teaching at law schools throughout my career, so I know a lot about law students, and I'm an expert in telling unpreparedness. I'm really very good at that.
It's very scary.
But you'll get away with it, and it reinforces the idea that, well, somehow who you are as a lawyer and your reputation as a lawyer is unconnected to the fundamentals of what you do. Particularly if you get away with it and somebody pats you on the back. Maybe you win. I haven't done much of that. But if you did actually win something and you weren't prepared, it will make you think that it's all right. You can be unprepared next time and you'll still win. And you think that win is in some way part of the reputation that you have earned as a lawyer. Utter nonsense. The reputation you want to have, I think, is the reputation for being the lawyer who is prepared, who would never lie in court. That would be nice, to go through a whole career and say you'd never told a lie to a judge or to an adversary. I don't know very many lawyers who could say that. But I'll tell you, once you've told your first lie and gotten away with it, becomes a lot easier.
A lie in what way? What do you give me an example?
Well, I think the common ones are the small lies about why you didn't do the things that you were expected to do, either by your adversaries or the judge. You were expected to have a brief filed by a particular time. You didn't get it done, and your answer is something in the lawyer's equivalent of the dog ate the papers. Mm-hmm. It happens every day, and I see prosecutors doing it all the time. I see them saying, well, Your Honor, it is true that we had our production deadline and we were supposed to produce all of these documents, and we did our very best, but the paralegal couldn't get them copied. Or they'll say, oh, those documents were produced. They were available for inspection. I don't know why counsel didn't come and look at them. And it may not be true.
What should they say instead? Should they just get it done?
They should either, it's a good idea to get the work done. That's a kind of a nice way to proceed. Or if you haven't done it, I find it very refreshing when a prosecutor stands up and says to the judge, Your Honor, I know I had a production deadline, and I know the court said that it had to be done, but I just didn't get it done. And I'm sorry, and I'll make it up to counsel. I'll have the documents sent over. I'll carry them myself on the way home tonight, and I apologize. What's wrong with that? And some good prosecutors do that, and some honest defense lawyers will do the same thing, but a lot of them won't. A lot of them will say it's just easier to kind of slough over that and to give us some handy little. What does it hurt? I mean, these are small lies. They're not lying about innocence. They're lying about documents.
And it seems like it goes back to kindness and community and integrity and reputation. I mean, it comes back to that again, that if you know that isn't the case, that they're lying on that little point, that it sort of disrupts community. I mean, unless the community is based on them, then that's a whole different thing. But sort of, I guess, it's sort of what we want our world to look like, and that little lie is sort of saying what you want the world to look like those actions. Do you think? I mean,
yeah, I think that's right. Most of us tend not to realize what happens when we don't maintain our standards. Everyone has heard the metaphor of the clock that strikes 13. But it is true.
I don't know the metaphor.
The metaphor is a clock that strikes 13 ought not be trusted on the other 12. Well, it's sort of the same thing about lies in court. Once you've said something that isn't true, ask yourself why anybody should believe you. On the other, it's the same thing with child rearing. Your kids lie to you, and I say to them, I know that's a lie, and I'm going to doubt everything else that you say to me. And they say, well, that's not fair. You're a lawyer and you lie all the time, and why should you have any different rules for your kids than you do for the legal profession? But I think it is true. I think that the blocks that you set, the who you are in the community, really turns to a very significant extent on how you deal with those little things that happen day in and day out.
All right, I'm going to ask some different questions, unless you have any other comments about anything we're talking about. Okay.
No.
Okay, these are the questions where I'm still not so good at. Hardest moment or difficult moment, or when you look back, you think, oh, I'm not so sure about that, my decision, or sort of that, I don't know, am I phrasing it right? Yeah.
Biggest mistakes?
Mistakes or struggles or clients or experiences that were just tough, that were tough experiences that sort of later you thought, I learned something from that experience that wasn't so easy to go through, I guess.
Mm-hmm. Well, for lawyers who do capital work, that's always that's a softball kind of question. Every lawyer who has done any significant amount of capital work knows that there are are those moments that happen in cases that you think, I just can't do this. The death of a client, the execution of a client, or the run-up to the execution of the client. Those days where you litigate at the speed of light, where you're in several different courts at the same time, and you can't sleep because sleeping takes time away from what may be someone's liberty and their life. The times when you realize that you don't have a family anymore, you don't have a life anymore, because every minute you spend with your family or with your social life is taken away from someone who may be executed. When those things are going on, there are times, and every death penalty lawyer I know has had those moments when they say, I just can't do this. I just can't do it. And after it's over, and again, I think this is almost invariably true, you look back on it and you say, it may be the most important thing I ever did. Living through those times when the case never seems to end, or when your biggest nightmare is that it will end, or it just.
Does it? We haven't talked about balancing in family. Is it part of your? I mean, does your family understand, or is that part of your sort of job as a lawyer to sort of be there for your family? But then when you have hard times, for them to understand, sort of, is that part of it? I mean, you say like, I mean, it seems like they'd have to be part of the process. Otherwise, they would just be angry all the time.
Yeah, I've given you some really important rules, like a league of their own and things like that. But one of my other important rules is what I call the pillow talk exception. I understand the importance of client confidences and of not revealing confidences without the client's consent, but I have an exception to that. I talk to my wife about things that probably another lawyer would say you shouldn't, but I have found we've been married for 34 years, and I think it sort of helps for her to know what's going on in my cases. I think it helps me to have somebody to talk to who is utterly supportive but not connected to what I'm doing day in and day out. I think it's important for your family to have an appreciation for what you do. It's also important to have some distance there so that you have a life apart from being a lawyer. But I think it's important for your family to understand what you go through as a lawyer and why it matters so much.
How do you, I mean, you do bring it home because you just said like you talk to your.
Sure.
But how do you, I mean, there's a lot of sorrow that you see. How do you deal with it, and how do you not just cry all the time? Or, do you know what I mean? Like, I mean, you're doing things for people, but it also seems like, is there a need to separate from the work, or is that just part of who you are, and it never sort of, it's always with you? I don't know.
Well, it's important to have a life. It's important to have some distance and some perspective. In cases, whether they're capital cases or whether they're not. I mean, we talked to a 17-year-old boy who is looking at 10 years in the state prison. May not be a capital case, but it's certainly the most important affair in his life, and it may wind up for some period of time being the most important affair in your life. It's hard not to be totally consumed by those things, but at some point being totally consumed sacrifices your own judgment. We talked about independence and the importance of being able to step back and have some judgment. Becomes very hard to do when you become so enmeshed in the client's concerns and in your work that you have no other life. You have no ability to step away and think.
So how do you do that? How do you, I mean, do you
I don't.
see you don't?
I'd like to. It sounded like a really good idea. I think it's important to recognize that it's okay. You know, it's okay to have a life. It's okay to read a book. It's okay to talk to your children. You don't have to be totally consumed by your clients. That judgment and separation is valuable. So if you get to that point that you feel like I just ought to spend 24 hours a day doing this, you don't have to feel guilty to say I'm going to go home tonight. I'm going to go see a movie. There's nothing wrong with that.
What about, okay, so these are kind of dumb questions. Have you ever been scared of any of your clients? Or that just not?
People ask me that all the time because I represent people who are thought of as the scariest people. Mm-hmm. The scariest guy in Arizona today in the minds of most people is a guy named Salvatore Gravano. He's known as Sammy the Bull. He is admitted to participating in the killing of 19 people. He's been my client for 6 years. I have never had the slightest fear of him. I've represented I don't know how many death row inmates. I've never felt. I've been arguing for years against this rule that there's no contact visits with people on death row, and that there isn't. We don't allow contact visits for the last, now it's been, I guess, 7 or 8 years. Before there was any glass barrier between lawyer and client, I never felt afraid. When we did the protective segregation case, representing some of the people who were thought to be the worst in the state, I never felt a moment of fear. When I go into a court with a client and the client comes in shackles, I always ask that the client be uncuffed. And some judges will and some judges won't. But I have never felt. I mean, the clients are smart enough to know that their lawyer may be the only thing they have going for them. I haven't represented someone who was so dumb that they didn't realize that I was important to them.
Do you think that it's in part you're kind, I mean, I don't know if you're kind, you seem kind, you appear kind, you appear like you care, but do you think that, I mean, if you weren't that way, do you think, I mean, I don't know. I keep asking everybody if anybody's ever scared. Nobody's scared, and that always surprises me because I'm scared of everything, so I would imagine but, okay, let me ask you another thing about your client, and then we'll talk more about, you said you want to talk more about death penalty. What people should do. And I talked to Professor Harcourt. We talked a lot about the clients that he represented, and he said that the justice system's such a mess that there's always something you can do for someone, and that it isn't like, I asked him, like, he brought up, I think, the thing of people saying that, like, they've done really horrible things, and, like, does that sort of creep you out too much, or something like that. But he had said those sorts of things, and I imagine that's sort of the same sort of thing that you would say on that sort of, there's a lot to be done, even if they have done bad things, kind of thing.
Yeah, I mean, it's, there are lots of bad things that people do, and it's a constant learning experience. And again, I think it's one of the richest parts of being a lawyer, understanding why someone commits a crime. Mm-hmm. And I'll give you an example of the learning experience part of this. I've been practicing for 31 years. I've represented I don't know how many clients. It wasn't until relatively recently that the research began to be popular, or began to be well known, about closed head injuries, about the very high percentage of people who commit violent crimes who have had some insult to their frontal lobe at some point in their life that has done some brain damage, that has contributed to why they act in a way that we would regard as criminal and abhorrent. And I've asked myself, how did I go through a couple of decades of being a lawyer and not often never even thinking, I wonder if my client fell off of an ice truck when he was 3 years old and was bounced on his head. I wonder how I got so many years into the practice without ever talking to a neuropsychologist, or to have a neuropsych eval done for a client. Now I do it routinely. But how did I go so long not even thinking that there might be causes that could contribute to why a client behaves the way she or he does? Well, that's just one small example of what happens, I think, in every client relationship. The more you look, the more you learn, and the more you understand how somebody could do something that we think of as utterly abhorrent and yet still be a life worth saving.
That's very interesting. It seems also that it's I can never say it.
Cumulative?
Yes, that word. It seems like, that the time you're spending with one client is, you're gaining knowledge. That it isn't a waste of time. Not that spending time with a client is a waste of time, but sort of the notion of it all
Sure.
makes a difference.
Yeah. If you want the real proof of that, talk to the mitigation specialists, the people who, most of whom are not lawyers, but who are really very good at looking at all of the explanations for why someone commits a crime the way they do. It's an endlessly interesting learning experience, and every time you learn something about a client, it may very well help you with the next client.
What about dealing with a difficult client? And what is a difficult client?
Yeah, well, most clients aren't experienced at being clients. So I think it helps in starting out a relationship with a client to understand that they probably haven't done that before. So they're learning how to be clients at the same time that you're learning how to be a lawyer. Tolerance is a really good virtue. I would like to have some of that. That would be a good thing to have. But it's a very important thing to give your client the benefit of the doubt. We all get angry and irritated at things our clients do. We often get angry and irritated because we don't understand the things they do. We don't understand the pressures they're under. And the more we get to know about the clients, the more they cease being difficult clients, they start being clients with difficult problems. All of us have clients that we don't get along with, that aren't our friends, that aren't on the same page with us, that we probably wouldn't want to spend an evening with. But I think, first of all, the lawyers who are honest with their clients, the lawyers who do what they say they're going to do, don't have very many difficult client relationships. If you ask the people at the state bar about what lawyers ought to do to avoid having bar complaints filed against them or having these very contentious client relationships, one of the key things is doing what you say you're going to do. So if you say you're going to call the client tomorrow, you call them tomorrow. If you say you're going to come to the jail and see him, you go to the jail and see him. If you say you're going to get the will drafted by X date, you do it. And if you don't, you tell them. Instead, again, of telling them a little white lie. Well, I did it and sent it to you. You didn't get it. Those things, I think, avoid having very many difficult client relationships. And when you do, by the way, one good thing is having people to talk to, having colleagues, having a friend that you can talk to and say, could you help me with this client? Could you help me talk to her or him? Really makes a big difference. Being a sole practitioner, I think, would be a very difficult thing.
Yeah, we had one interviewed, and she said she had lots of network of people, that she needed that as part of, because she needed people to talk to.
I agree with that.
Yeah. All right, tell us about your strong opinion about the role of lawyers in a death penalty state.
Well, here's what I would submit to you. If you're going to practice law in a state that has the death penalty, if you're going to get a bar card and hold yourself out as a lawyer, it behooves you to know something about our death penalty. It is not acceptable, in my judgment, for a lawyer to practice law in this state and not ever to get her hands or his hands dirty in the death penalty. And so at a bare minimum, I think it's important for lawyers to know how the system works. You know, when we speak to lawyers and we ask them, who does the sentencing in Arizona in death cases? You know, the majority of lawyers, every time we give this speech, and I've done it many times, the majority think that juries do the sentencing in death cases. They don't. The sentencing is done by the judge in our state and 5 others. Yet in our own state, we have people who are so ignorant of how our system works that they think it's done by a jury. Inexcusable. There are very few situations in which lawyers who don't do capital work ever go watch a death penalty trial or ever talk to a lawyer who's doing one of those cases, either prosecutor or defendant, in anything more than the most superficial way. It's like we all want to stay away from that. Well, I would submit that that's not acceptable. I think if you're going to be a lawyer in this state, you ought to set aside some time and you ought to go watch a capital trial.
Why?
Because I think it more than anything else in the world of law and society, the death penalty defines what we are. The death penalty and the way we administer it defines our justice system. You can't have a good justice system and a bad death penalty system. If you have a corrupt capital system, the rest of the system doesn't matter. And people who think that they can authoritatively comment on what our law system is about without knowing anything about our capital punishment system, I think are basically ignorant people. I don't think it's acceptable for an attorney general or for any other lawyer to say that they know something of consequence about our system of justice if they don't know about the death penalty system. For instance, how is it possible that everyone on death row is indigent? How is it possible that the clients I represent at trial never get the death penalty? How is it possible that if you're lucky enough to get Mike Picaretta or Bob Hirsch here in Tucson to handle your case at trial, you will not get the death penalty? But the people who are left in the hands of those who have no resources get it. How can anybody feel comfortable about that without spending some time thinking about what we have here in this state?
One second.